Next, Eric J. from Oregon says, I have grand jury duty for 5 weeks starting mid-October. What would be your advice for me to be the most effective as a grand jury member in such a liberal area? So it's a liberal area of Oregon. So I don't want to name the area. That would be too specific. But Eric, it's very difficult. Well, I guess it depends on what you mean by being an effective grand jury. So in theory, the grand jury is supposed to be a barrier that the state has to overcome if they want to drag a citizen into a criminal trial. And we have these theoretical barriers because the process of a criminal trial is unbelievably destructive. Even if you're ultimately acquitted, the legal costs can easily be in the hundreds of thousands of dollars, and there's never a 0% risk of getting convicted. You could be the most innocent defendant in the world, and if you're put in front of a jury, there's a 10% chance you get convicted. That's just the noise in the system. So in theory, we don't want to expose citizens to that legal risk and that tremendous expense and that tremendous disruption in their life. And by the way, if the grand jury returns if you've been charged with a crime like murder, you may not have bail. You may be stuck in jail for a year or two or more until your trial actually happens. That's what happened with Dean Cummings, the skier, the murder trial we just covered. He sat in jail for 2.5 years awaiting that trial. And when it finally went to the jury, they returned a non-guilty verdict on all charges within a couple of hours. And that includes the lunch break. I mean, the whole prosecution was ridiculous. So and he could have been convicted. I mean, one of the reasons I don't predict verdicts is I don't know what that crazy jury might do. Juries are dangerous and unpredictable creatures. I can tell you what they should do on the legal merits when I'm watching a case, and I do that. What a rational, impartial, unbiased jury who follows the judge's instructions and applies their powers of reason to the law and evidence presented to them in court. I can suggest what the verdict should be on the legal merits, but you never really know what a jury's going to do, in fact. So gratefully, they acquitted Dean Cummings very, very quickly. And that tells you how little merit there was to the prosecution's case. And yet Dean Cummings had to sit in jail for 2.5 years. So we have this thing called the grand jury. We have similar barriers, theoretical barriers, probable cause hearings, that are supposed to be a barrier that the prosecution has to overcome before they can put you at the cost and risk of a criminal trial. And both the grand jury and the probable cause processes are completely broken in America. There's effectively zero barrier a prosecutor has to overcome to drag you into a criminal trial with all that legal risk and cost. It shouldn't be that way. It's a broken system. It has been for many years. Generally, the criminal justice system ignores this broken aspect of the system because the system's really designed to deal with guilty people, to deal with actual criminals, and so nobody really cares if there's not much of a barrier to dragging those people into trial. It's when a non-guilty person, a non-guilty defendant, is fed into the system that we see this for the outrage that it is, that at a whim, a prosecutor can drag someone into a criminal trial where their life could be at stake. So one of the challenges with being a member of a grand jury is you have a duty. Your duty's supposed to be, well, has the state presented sufficient evidence that this person should be put into a criminal trial with that cost and risk? But you're not really given the information you need to make an informed decision because generally the grand jury only hears the prosecutor's side of the story, the prosecutor's side of the narrative. They only hear the narrative of guilt. And we all know if you only hear one side of an argument, the side you hear sounds pretty compelling. But the grand jury has no real adversarial process. The person charged has no real ability to tell the grand jury their side of the story. So that's why we have these cliches, like a grand jury could indict a ham sandwich, right? And it's true. Unfortunately, it shouldn't be that way. What can you do as a grand jury? I mean, I guess you can kind of keep in mind that you're only being given half the information, half the narrative, but you don't know what the other half is. No one's going to tell you that. So really all you can do is follow your instructions. I mean, a judge is going to instruct you on your duties as a member of a grand jury, and just adhere to those. Are you going to end up returning indictments on people who probably shouldn't be dragged into a criminal trial? Let's hope not. Most of the cases that you'll be looking at are again, most of the people fed into the criminal justice system are criminals. It's rare that you have a genuinely innocent person fed into the system, but it happens. And unfortunately, as a grand juror, there's really nothing you can do about it except follow your instructions. It's awful. It's awful, and it should be fixed. I mean, we have this thing similar function to a grand jury, a probable cause hearing. To my mind, a probable cause hearing should be asking the question, is it probable, more likely than not, that this person is guilty as the state has charged before we can drag them into a criminal trial? They should at least be more likely than not that they're guilty before you put them to the cost and risk of a criminal trial, where, of course, then their guilt has to be proven beyond any reasonable doubt. But people get dragged into criminal trials all the time when there is, in fact, not probable, more likely than not, cause to believe they committed the crime. At least if you hear both sides of the narrative. And this was true in the Rittenhouse trial. This is true in the George Zimmerman trial. This is true in the Dean Cummings trial. A lot of these high-profile trials, it's ridiculous that they're going to trial. They generally result, thankfully, in acquittals, but at tremendous expense and time. 2.5 years in jail for Dean Cummings, and risk. You know, I watched the entire Rittenhouse trial. There was no evidence presented there that was inconsistent with self-defense in a case where the state has to disprove self-defense beyond a reasonable doubt. And I watched every minute of that Rittenhouse trial, and nothing changed. It was clear that the prosecution did not have a compelling argument disproving self-defense beyond a reasonable doubt for any of the people, any of the criminal charges against Rittenhouse in that case. But when that matter went to the jury, you weren't seeing me make $10,000 bets that Rittenhouse was going to be acquitted, because you always have the risk that the jury might go the other way. Little Miss Jacob in the chat with a super chat, $5. Nothing but love for you too, Ari. I wish you nothing but the best and happiness and all the good things in the world. No, there's zero personal animus on my part. I had a great time chatting with you. I might have been rude. If I was, I apologize. But certainly no hard feelings on my part, whatever. All right. So this is the first time I've been doing these platinums in a while. Let me see. I should take a look and see if any super chats have gone in following those first couple of questions. Let's see. By the way, these questions I'm answering, folks, are from our platinum members. Law Self-Defense Platinum members have access to a form. They can type in whatever legal question they want, really. Of course, my expertise is use of force law, and that gets submitted directly to me, and I personally answer their question guaranteed. That's part of the benefit of being a Law Self-Defense Platinum member. They have immediate access to me and my expertise.